County and have been since 2011. Good morning, everyone, and thank you for being here. I guess I want to start off today by just saying thank you and acknowledging that everybody who's here right now, you're here because, or at least as I understand it, and from talking to Sue Sun, that a lot of people who are here want to understand how to be of better service to victims and want to understand more about the system that we work in. So that way, when people come to us with questions, we can give them answers. And so, I hope that I can be of service to you today in that regard. Just as a heads up, yesterday afternoon, I went home feeling sick. So that's the reason why I'm working home from home this morning. And so you're going to see my dog in the background. I am sorry, kind of, about my dog, but he's very good and he'll probably be quiet. So with that, no further ado, let's talk a little bit about what do we mean when we talk about criminal law and the criminal legal system. What are we really talking about? And I guess I kind of go with this big question. It sounds sort of like abstract and a little bit law schooly to say, okay, well, what is criminal law? And when we talk about criminal law, that's very different from other areas of law that you might be familiar with. So, family court, divorce proceedings, or contract disputes, or somebody suing somebody else for money. And I'll kind of take a moment for everyone here to maybe drop it into the chat. If anybody can give me an example or an idea of why and how criminal law is different from those other areas of law. And if anybody wants to jump in, that's fine. And if not, don't worry, I'll provide an answer. I promise I won't leave you all hanging. And yep, process within the court, county versus defendant. Oh, those are excellent. All right. So I would go pretty big picture. If I'm going to start off by saying, the processes are different. So I see that from Samantha Quinn, and who the litigants are. County versus a defendant from Renee, I see that too. Those are both great points. I would point out something really fundamentally different and a little bit bigger. And that is when we talk about criminal law, we are talking about an area of law that deals with the government having the power to sanction and punish someone, and that punishment including physical custody or incarceration. So, good definition. But really, what we're talking about when we talk about criminal law is we're talking about things that we absolutely don't want people to do. And I remember when I was in law school, I had a professor explain it this way. Well, why don't we put people in jail for breach of contract cases? Microsoft sues Apple. Well, one of them owes the other money. Well, why isn't a sanction on the table for the CEO of Apple to go to prison? Well, it's because it's not like when we enter into contracts and have contract disputes that we just want to sanction that kind of behavior, meaning we want people to enter into contracts. But with things like drunk driving and physical assault, murder, it's not like there's an acceptable amount of that behavior. The amount and the ideal amount of that behavior is zero. And so things where the amount that we would want in society is zero, that's when we make those things into crimes. So that makes it very different from a family law or a divorce dispute, right? Because we don't want to discourage people from getting married. The idea that, well, if you get married, you could wind up getting thrown into prison or entering into a contract if you run a business. Or, if you run a grocery store, well, if somebody slips and falls, they could get hurt and then you could wind up going to jail. We're not comfortable with that idea, right? That could discourage people from doing what's really kind of valuable work in society. So that's why it looks different. But with crimes are different because they're things where the amount that we want of those in society is zero. So with that in mind, let's talk about what are our sources of criminal law. And when we're dealing with those today, I'm going to be primarily talking about crimes within California, but we also have federal law. And there are other sources of law that we get sort of criminal statutes from, but these are the two big sources. One, the California Penal Code, and the United States Code 18 USC, starting at Section 1. That's where a lot of federal crimes come from. But that's where all of our laws are kind of written down, where they deal with things that are against the law and things that are punishable either by an imprisonment in county jail or in state prison, things that we would call crimes. Okay. So if we understand the sources of criminal law, meaning what are the laws, where do we get them? Well, then how does a case get filed? How do we go to actually having a case where somebody like me gets involved, a district attorney? Well, I'll give you kind of a roadmap here. How do we even have a criminal case at all? What is the criminal legal system made out of? Well, I guess first step is you have a crime, right? And of those crimes, it has to be a crime that somebody investigates. So, as you kind of see that roadmap, or some of you have kids, you play Candyland. We start off there with the scene of a crime, and it's one where somebody reported that crime or investigated it. Police came, they took statements, they collected evidence. And when investigators did that part of the job, then they reduced that work or that investigation to a police report. That police report is then submitted to a district attorney, right? So a district attorney being somebody who has my job. And a good chunk of my job, not the whole thing, but a good percentage of what I do is reviewing police reports and analyzing those reports for, well, is there evidence where I could file a criminal case or not? And here are those last three steps where you can kind of see I've kind of made a line that goes towards district attorney, and it either goes one of two ways, right? It's either the district attorney does not file charges or they do. And that's where I get involved. That's where the criminal legal system also gets involved, because the way that our system works, if we have a district attorney who says, well, there's not enough evidence to prove a crime, well, then it doesn't move forward. That person, unless they were arrested and held for up to 72 hours, other than there being some record of the fact that they were arrested, beyond that, and potentially being the subject of a restraining order, we don't have a criminal legal system that holds them accountable, except for through this process, meaning through having a district attorney getting involved. So, and I'm sorry, and I see the question from Renee. This is literally criminal legal system 101. And yes, that is the subject. I also see from Leanne Fotzer, we're not here for a law school lecture, but I think it's important to still kind of know where that's coming from. So I'll move forward. So what does a prosecutor consider in kind of deciding whether or not a case is going to get filed at all? Well, I'd say it kind of comes out to two big categories. All right. It's first, evidence of the crime itself, and also look at the prior relevant history that may bear upon factors of whether or not the crime in this case can be proven beyond a reasonable doubt. Well, let's start by talking about evidence from a crime. All right, well, what does that consist of? All right. Well, first, it's going to consist of statements that are collected by peace officers from people who are eyewitnesses. So people who were actually there. If somebody saw a car being stolen, somebody saw someone being physically assaulted, or in the case of somebody who actually was physically assaulted themselves, the police coming in and taking a statement from that person. In addition, police sometimes are able to collect evidence or take photographs. You also increasingly see a number of police agencies that have body cameras and body camera units that are worn. So sometimes what officers are able to observe right when they arrive on scene is able to be contemporaneously recorded. So the statements that people make right when police arrive, this can sometimes be really important. Evidence of what someone says in a 911 call, also relevant. Sometimes we have it, especially in the age of cell phones, where someone may call the police in the time when a crime is ongoing. You may actually have audio evidence of a crime, for example, very common is kidnapping. That can be captured contemporaneously. Also things like robbery or dissuading a witness from testifying if somebody grabs a cell phone from a victim. Those are things that are sort of relevant pieces of evidence that get collected. And then we have the more sort of exotic or forensic pieces of evidence that police will gather in their investigations, those being things like cell tower data or fingerprint or DNA evidence. So then we get to the subject of prior criminal history. All right. So what does a prosecutor consider when they consider prior criminal history? Well, one of the things that you'll look at is, and one of the most important things for a jury, well, has this person committed a same or similar offense in the past? Is one of the things that's going to bear upon the kind of evidence that can be presented later on in a criminal case. So when a prosecutor gets a case, a lot of times police will present them with one page or a document that is called their record of arrests and prosecutions. And any of you who have ever dealt with, any of you who've ever watched Law and Order, right? When you hear the term rap sheet, might sound like kind of an archaic term of art. What it actually stands for is record of arrests and prosecutions. That is a rap sheet. So that's going to list arrests by police agency, and it's going to list any convictions. Also, if there are police reports related to, in the context especially of domestic violence, the same suspect and the same victim, those things could wind up being considered. Prior convictions, especially if they are for the same offense, and also evidence of prior restraining orders, and especially that's relevant in the context of either sexual assault or domestic violence cases. Now, I want to specifically highlight the latter three of these categories, because in a prosecutor doing their job, these are going to be sort of your big factors. Because the reality of it is, if somebody has been arrested for an offense, but never gone before a judge on it, has never had that case like adjudicated in any way, the evidentiary force in a later case is going to be limited, because at the end of the day, a defense attorney can say, well, yeah, the person was arrested for it, but nothing ever happened. The person was never convicted. However, in the context of domestic violence and sexual assault, there are specific penal code sections that allow for the introduction of prior convictions in a later case involving either the same crime or the same type of crime. And it makes sense, right? Just like if a person had robbed 15 banks in the past, right? If now you get to the crime where it's the 16th bank, it would be very relevant to know when the person walked into the bank, well, yeah, they've actually robbed a whole bunch of banks in the past, and then they walk in, ski mask, money, note that says, hey, give me the money, right? And in the same way for domestic violence, I would say, and the law actually says that there's evidence code section 1109. Prior acts of domestic violence where they result in a conviction are going to wind up being relevant. Now, if you don't have a conviction, prosecutors can still argue to bring in acts of those kinds, but it creates sort of an evidentiary battle that we have to fight in court. And we'll talk a little bit about that later. All right. And now I want to move forward and talk about one other issue. As we're talking about how we can be of service to victims that we work with and members of the community, there's something that gets talked about in pop culture a lot. And I put up you kind of see this over and over. It's any time that you have people standing, all kind of presented Last Supper style, either on the steps of a courthouse or as part of like a special victims unit, and that's the TV show. They're always going to ask, is the victim pressing charges? That is something that happens on TV all the time. But the reality of it is, the victim pressing charges or not is a relevant consideration, but it's not the end-all be-all of whether or not a prosecutor decides to move forward with charges. And let's think about that. If I have evidence in the form of 3 eyewitnesses who actually see a crime happening, let's say a robbery, all right? You can see somebody on the street getting their purse taken. being punched, being knocked to the ground, they have their purse taken away, and the person runs, and they're caught maybe half a block away. Well, if the victim says, you know what, I'm good, I'm not pressing charges, you can envision a prosecutor saying, well, that's still really reprehensible conduct. It's still really dangerous. It still really endangers the public and public safety. And so the public still has an interest in curtailing and preventing this type of crime in the future and preventing this person, the person who committed the robbery, from doing it again if they so choose, right? So in that scenario, you can imagine why a prosecutor would say, well, even if the victim says, I'm not pressing charges, the end all be all is, well, can I prove it or not? And that's when we talk about the burden of proof. Now, one facet of criminal law and how it is different from other areas of law is the burden of proof at issue. In a civil case, the burden is going to be a preponderance of the evidence, right? It's evidence more likely than not. In some cases related to either child custody or child welfare matters, there's a higher burden of proof. The highest burden of proof in the United States is proof beyond a reasonable doubt because we are dealing with such high stakes, that being the government taking away somebody's liberty. So I'm going to stop right there and I'll kind of open it up if anyone has any other questions or anyone has questions right now before I move on. Yeah, okay. Okay, then with that, let me keep going. Oh,
There is
yes.
a
So,
question.
question from Marie Davalos. Thank you. So, can a prosecutor press charges even if victims don't want to? And yes, that's what I'm referring to when I talk about the idea of if the victim doesn't want to press charges. Yes. The question is, can the prosecutor still prove the case beyond a reasonable doubt? Meaning, the victim does not control and isn't ultimately responsible for whether or not prosecutors bring a case in court. So, I used our robbery example from a little while ago, Marie. Um, Even if that victim of a robbery, where you have three eyewitnesses to the crime, where a person's essentially caught red-handed, even if the victim said, "Well, I don't want to press charges," prosecutor in that case could very well say, "Well, that may be. However, we are going to press charges or present a criminal case because of the quantity and quality of the evidence that we have," if that makes sense. All right, so Marie, does that answer your question? All right, cool. Okay, so how does a case get filed? You're going to hear, if you talk to prosecutors or if you are dealing in the criminal legal system at all, you're going to hear a couple of different kinds of terms. You're going to hear complaint, information, and indictment. More commonly, you're going to hear those first two, complaint and information, and here's why. So a complaint is a list of the charges that the DA has that they initially file with the court. And an information is what is presented or what is charged after a hearing called a preliminary hearing. There's a different way of charging criminal cases called an indictment, which happens when we're dealing with grand juries. Now, we see grand jury cases in California less often. There are other cases that other states that have a grand jury system, California not being one of them. That's to say they have a much more robust grand jury system. So when you hear the term complaint, that is the initial charging document, but they all serve the same function. They list the charges according to the penal code of what a person is charged with. So I'll give you kind of an easy example. This is what one's going to look like. I redacted the information here, but this is a case, and it actually happens to be one of my cases. And you can see right there you have count one, count two. So domestic violence, followed by kidnapping. And then you can see on the top you have kind of the remainder of the charges that are listed. And they're listed according to the penal code section, or one of those is a vehicle code section violation, that the law that was broken. So what happens when the DA files a criminal case? Files a document that says, hey, these are the laws that we, the prosecution, think were broken. Well, from start to finish, we start off with what's called a complaint. And from that complaint, Then the defendant gets brought into court. And the defendant gets brought into court to essentially get read or advised of the charges. Usually, if they don't have a lawyer of their own, that's the time when they will be appointed counsel, and they will have what's called an arraignment. An arraignment is when it's a formal proceeding having the judge say, look, have you been advised of all of these charges? And if so, how do you want to proceed? Now, I want to talk to people who work with victims or victim advocates right now, because one of the big things that I deal with at this point when I talk to victims and their families is that at the time of arraignment, usually the plea is not guilty. And I say usually, no, the plea is not guilty like 99.999% of the time. At arraignment, it is the first thing that happens until later on, there's going to be some kind of a resolution in the case. So when I talk to victims about the arraignment and they say, well, he pled not guilty, but it happened. He did this. So why is he pleading not guilty? That's what amounts to kind of a nuance of our legal system, because at that point he has an attorney, and that attorney is going to say, well, hey, I wouldn't be doing my job if I didn't take time to look at the case and then make a decision about how to proceed. Now, an arraignment is also a time and one of the stages when things like, does the defendant stay in custody or not, gets decided. What is the bail going to be, if any? And the case moves forward from there. Now, if we're on a misdemeanor case, you go from complaint to arraignment, and then just from there to a jury trial. But in felony cases, which is a lot of the work that we deal with in the criminal legal system, the next stage is what's called a preliminary hearing. And people who work with victims, victim advocates, social workers might be familiar with a case being set for preliminary hearing. Now, what is a preliminary hearing? Well, that is kind of like giving a judge a snapshot or a trailer or a sneak preview of what the evidence is that the government has to prove the case beyond a reasonable doubt. But at a preliminary hearing, my burden of proof is not proof beyond a reasonable doubt. My burden of proof is what's called a strong suspicion. That just means that it can be kind of like stated more likely than not. It is there enough evidence for a reasonable person to entertain a suspicion, and a well-grounded suspicion, that a crime was committed and the person in court is the person who did it? The big thing in California is that at a preliminary hearing, sometimes detectives and police can testify in the place of a victim. And I note right now that I see a hand from Diane Healy. So if you have a question, jump in. Hold on, I'll move forward, and then once your question is up, if you just want to pop it into the chat, that's fine. Okay. So if we have a preliminary hearing, then we move forward to the next stage, that being the judge deciding, well, is there enough evidence? And if there is enough evidence, of what crimes? And those crimes get put on a separate document, that being the information. And then you have another arraignment, an arraignment on an information. And that information just says, well, these are the crimes that the prosecutor says were committed, and a judge agrees that there was enough evidence of those crimes. So from there, you move forward to resolving the case towards either a jury trial or a plea. Well, if we state it that way, just these 5 phases of the trial, boy, it all seems like that would probably happen really fast. It seems like this should be like, so what do we settle a case in, like a month? But we all know that that isn't really how it works. And why is that? Well, here's why. As a practical matter, in the time between an arraignment, a preliminary hearing, and a jury trial, we have other court dates that get included, which are called settings, or change of plea or set dates. Sometimes those are the dates when somebody says, well, look, either we'll plead guilty or we'll set a future date on this next court date. So right now, what I'm talking about are these dates here. So all the times in between a preliminary hearing and a jury trial, or between the initial complaint and the preliminary hearing. Well, what happens in those time in that time? That's the time when either the defense attorney will try and approach the prosecutor to discuss a resolution. Sometimes they will put together like packets that we sometimes call a mitigation packet. Hey, here's the things that I would like you to know about my client or my client's background. So that way, here's a reason why my client might be deserving of either a better deal or a better offer in the case. Separately, those would also be the times when defense attorneys would work on things like trying to investigate the case from the defense's side. So in understanding how we move through the process, it's helpful to have kind of the discussion about who's who. So on the one side of the case, you would have police, you would have the district attorney, who also acts as sort of the prosecutor, is another term for the same job, or victim advocate. And those people work to keep a victim informed of the upcoming court dates, the job of the victim advocate, prosecute the case, and investigate the case as it moves on. Defense attorneys sometimes retain private investigators or investigators from the Office of the Public Defender. And their job is to look for or try to collect evidence that's favorable from the defendant and to try and, by any legal means, get a better resolution of the case from the defense perspective. Judges have the job of ensuring that all parties conduct themselves according to sort of the rules of evidence and the rules of the road. And then you have probation officers, where we'll talk in just a little bit about their job. Now, I want to take a moment and talk a little bit about distinctions as between defense attorneys and public defenders. And Diane, I see your question, so I'll come back to it in just a minute if that's okay. When we talk about public defenders versus defense attorneys, legally they take on the same function, which is they both have the job of defending the defendant. The difference comes out when you have one being paid or privately retained, meaning somebody paying for that attorney out of their own pocket, versus a public defender. Sometimes in working with victims and their families, there comes this discussion of, well, is one better than the other? And I have to tell you, I've been a prosecutor now going on like 12 years. I have to say the answer is no. And really, it comes down to the individual performance of any one lawyer. So you have public defenders who sometimes are outstanding, and outstanding compared to attorneys who somebody pays money out of their own pocket for. To say that one is just categorically better than the other, I don't think paints an accurate picture of what our legal system actually looks like. So I want to stop for a moment and I want to answer Diane's question. So if a victim doesn't want to press charges, are they compelled legally to cooperate with the DA and the court? All right, that's a great question. And I get this question not infrequently. So cooperate with the DA and the court. Broadly, I would say, is a victim under any obligation to either talk to me or assist me in any way? No. But all parties in a criminal case, just like all parties in a civil case, have what's called subpoena power. So I do have the ability to bring a witness into court and ask that that person be placed under oath. That's really the only power that I have. Otherwise, no, a victim can't be compelled legally to cooperate. They can, however, be compelled to go to court. Now, if someone is the victim of domestic violence, they face a different set of sanctions, meaning you can't put somebody in jail if they're the victim of domestic violence and they don't want to go to court, or they don't show up in response to a subpoena. With some witnesses, that person could actually be held in contempt of court. However, in the case of domestic violence, you can't do that. So for most victims of crime and victims of domestic violence, the only sanction, the only power that I really have is the power to bring somebody into a courtroom. What happens from there is really a matter of questioning that person, question and answer, and that's it. So Diane, does that answer your question? All right, cool. All right, really appreciate it. And I'm happy to talk more as we get towards the end. We can circle back to that too. I have no problem with that. So now let's move forward to when we talk about defense attorneys. Sometimes in the criminal process, I will get questions from victims and victim advocate or victims or their victim advocate, like, all right, well, why isn't the defendant taking a plea deal? All right, or what is the defendant saying happened? Like, look, the police came out, they collected a bunch of evidence. Everybody, they got statements from everybody who was there. So what is the defense going to try and say happened? Or what has the defense told you, meaning me, the prosecutor, about what they're going to say happened? And that's an interesting area because it touches upon an area of what's called attorney-client privilege. In a criminal case, I sometimes style it as or refer to it as asymmetrical warfare because although the burden of proof is against me, the prosecutor, meaning I have to prove the case beyond a reasonable doubt to 12 jurors, I have all the evidence. I made the decision to charge the case. Me or someone in my position made the decision that we could prove this case in front of a jury. The flip side is that the defense doesn't have the burden to tell me what their theory of the case is. They don't have to, subject to some rules, disclose evidence to me in the same way. So very often, strategically, it's to the defense's advantage to, quote, play their cards closer to their chest. So I'm in the unfortunate position of telling victims, well, why isn't the defendant taking a plea deal? I can only guess. Because from the time of arraignment, I will never really have the opportunity to talk to a defendant directly. And when a defense attorney talks to me, it will be very rare indeed that I'm actually given information about what the defendant and the defense attorney have spoken about. Usually, the defense attorney will give me their position, but not talk about what their client actually said to them. And that's a strategic decision that the defense attorney makes. I don't fault them for that because that's just essentially what I would do if I was a defense attorney. That is good strategy. And that's also then being mindful and rigorous about minding the attorney-client privilege that they're bound to. Does that make sense to everyone? Does everybody understand what I'm talking about? All right. So when we move forward through a criminal case, most cases are going to they're going to resolve one way or another. And the question is how? Well, most cases resolve by plea. They either resolve by pleas of not guilty or no contest, or sometimes either not guilty, case being dismissed. Now, when a case when a case resolves by plea, the initial pleas are going to be not guilty. And then when a case resolves by plea, you'll see a plea of guilty or no contest. So when a case resolves by way of a plea, either a guilty or no contest plea, there are different outcomes that we have in the criminal process. Those being either somebody being placed on probation. Probation sometimes has a suspended state prison term attached, but the big function of probation is a form of local supervision in the county where a county probation officer will advise someone of terms that they have to follow. Could be things like medication compliance, drug terms, submitting to Alcoholics Anonymous meetings. Could be abiding by restraining orders or participating in anger management. But all of those things have additional sanctions if someone doesn't, for lack of a better word, either follow or comply with those terms. Somebody could be put back into custody if they don't. And then you have additional terms like somebody being placed in a county jail sentence or a prison term. The difference between those things usually deals with the length of incarceration. If it's a period of time that's over 1 year after a sentence, then they're going to prison. My quick legal answer is they'll be going to what's the equivalent in California of prison. Shorter than a year, we would call that a county jail we'd call that a county jail sentence. So let's talk a little bit about trials. So when we have a jury trial, things to know about a trial. The defense and the prosecution both have the right to a trial by jury. Both sides, if you were not going to have a jury trial, would have to waive that right. It's very rare that a case is tried before a judge and not a jury in a criminal case. The times when it is usually limited to things like somebody pleading not guilty by reason of insanity or a few other kind of more exotic legal issues. There's always going to be a judge. Everything is done in person, and the defendant is present. Now, when I talk to people who don't know anything about the criminal justice system, when I talk to victims, when I talk to children who sometimes have to come in and testify, their first question is, one, do I have to be there? Do I actually have to go in? And two, will the defendant be there too? Sometimes people ask, well, is there a way for the defendant to appear like remotely, to have the defendant on video, or to use something like what we're doing right now, right, as Zoom? And the answer to that comes from the United States Constitution, right? That is, and I put up the First Amendment. This actually comes from the Fifth and Sixth Amendments of the U.S. Constitution. It is a right to a trial by a jury of your peers, and also a right to confrontation. You have the right to confront and examine the witnesses against you. And so, unfortunately, our Constitution places limits on how a trial has to be conducted. Now, there's ways in which that can be stressful for victims. It's stressful for victims and their families. And so the job of a prosecutor and a modern DA's office is to have kind of a robust victim advocate office or a victim advocate branch that does things to try and make that process less painful or less stressful on victims. Some of the tools that we use include court tours for minors. I also find that even for adult victims of crime, just going into a courthouse and a courtroom ahead of time is really, really valuable. And I think that's true because when you bring somebody into a courtroom, if they're being brought in for the first time to testify, it's a stressful experience because you're coming into an unfamiliar place. You bring somebody into a place that's maybe a little bit more familiar, it takes some of the stress or scariness out of it. You'll also hear, and I think probably many of the people who are here today have heard about like courtroom dogs. Our office utilizes a dog named Bear. We had Jojo before. Both dogs outstanding. I am a huge fan of dogs. So Bear now does a really great job of working with victims. You have a dog essentially sleeping on a kid's feet while they testify. It does a really good job of taking the temperature down in a courtroom. So moving forward, I do want to talk a little bit about the stages of trial. So we've gone from the point where we've had the arraignment. After the arraignment, we've had either probably a preliminary hearing if we're dealing with a felony case. Now we've had an arraignment on an information. The case has been set for trial numerous times, and then we reach a jury trial. And this is where when I talk to victims, what I have to say is, all right, they'll say, well, what date is the trial? And example for me, because I have a trial coming up, all right, I'll say it's May 9th. And a victim might say, well, all right, I'll be there on May 9th. At which point I say, no, you do not need to be there on May 9th at all. And the reason you don't need to be there on May 9th is because, look, there's a lot of things that have to happen before we actually hit the stage of having a victim testify. In a criminal case, you're going to see that the first thing that happens are what are called motions in limine. Those are our rules of the road. Separately, and that's where we're going to decide what evidence is admissible at trial. I talked earlier about evidence that could be used in a criminal case or evidence that would be excluded. What are the jury instructions that the jury should get in this case? What things are either the defense attorney or the prosecutor allowed to cross-examine witnesses about? Well, next up would come jury selection. And when I explain to people how long jury selection takes, I like to compare it to innings in baseball because there's no set time period. How long is jury selection going to take? It takes about as long as it takes to pick a jury. I can't tell you anything more than that. I usually have either a guess or an estimate about how long that might be, but it's always going to be exactly that. It's going to be guesswork. After that point, then we get to what we call the bulk of a criminal trial. First, opening statements. Then you'd have actually the presentation of evidence. This being the point in time when witnesses would come into the courtroom. They'd be questioned first by the prosecution and then cross-examined. After the prosecution presents their case, then flip side. If the defense has any evidence, then the defense attorney would have the opportunity to present theirs. Then you would have closing arguments by both sides where they argue what the evidence meant, and usually with reference to the law that the jury's been instructed on. And then the jury deliberates and decides on the verdict. So, great question from Sonetta Freeman. Why wouldn't I want to be present for every part? Great question. All right. And I'll tell you, and from Sonetta Freeman, I think the question, why wouldn't I want to be present for every part? Assuming that we're dealing with a victim, well, wouldn't the victim want to be there for the entirety of the trial? I mean, that's a great question. The answer is that if you are a victim of a victim in the trial, as the victim, there are actually parts of the proceedings that you would be excluded from the courtroom for. Largely, that's based on times in the trial where other people are testifying. So, for example, there is an evidence code section 777 that states that a victim in the case cannot be present during the trial while another witness is testifying. Same goes for all eyewitnesses. And we can imagine that being the case because let's say I have 7 people who observe something. Let's make it something pretty mundane like a car accident. Well, if I've had 7 people and I had 6 of them sitting on a bench watching the trial, watching the first person testify, we can imagine what would happen, right? It would be that the first person would testify, and then the second person would testify and might have their memory legitimately jogged by the first person. But then the third person would testify, and maybe the words that they would use, the language they would use in talking, would probably start to sound about the same as the first 3 witnesses, on through the 5th witness and the 6th, and so on, right? And that's the same concern underlies regardless of how many witnesses you have or whether or not it's a victim versus a witness to a crime. Separately, as a prosecutor, one of the reasons I wouldn't want the victim to be present in the courtroom is because, especially for something like my opening statement, imagine as a prosecutor, I put a victim on the stand who was there to watch my opening statement. Well, what did the prosecutor say the jury was going to hear, right? If I was the defense attorney, the first question would be, well, wait a second. You sat here through the whole trial. You actually heard the prosecutor's opening statement, right? You knew exactly what he was expecting you to say. And so that's why, for example, the answers that you gave, you knew that he wanted you to say that, right? You knew that he was hoping that you would say X, Y, or Z. And I don't want to create the appearance of impropriety or the suggestion that a witness is testifying in a way that kind of bends to what I, as the prosecutor, was hoping or expecting the evidence would be. You want to make sure that when people are giving their testimony on the stand, it comes off as a way that it comes off in a way that you know that you're actually getting the truth and you're not getting what just makes either one side or another happy, right? The goal of presenting testimony is just to testify to the truth. Sometimes in our house, we like to say, if you tell the truth, you're bulletproof. And that's the advice that I give. It's as long as you take the oath to tell the truth, and you do, I, as the prosecutor, can handle most anything else that happens up there. We're going to be okay. But if the jury is left with the impression that a victim is kind of bending their testimony in a way that favors the prosecution, it actually hurts the underlying prosecution case. So, Sonetta, does that help to explain what I'm talking about, or kind of things from my perspective? Okay, but that was an awesome question. I really appreciated that. So for the time being, we have been going for about 50 minutes. So what I want to do is I want to give everybody about maybe let's take a 5-minute break, and then let's come back, and then we can ask some people questions, and we can kind of open it up for a Q&A if that makes sense.
Yes, I think that's a great idea.
Awesome. All right, I really
5 minutes,
appreciate it.
everyone.
And 5 minute if 5 minutes works for everybody. Okay.
I think that's good.
All right, thank you.
Thank you.
All right, but I'll flag that. Sorry, sometimes I will flag that instruction our for our jurors, depending upon whether or not it's important. But more than that, there is a process through what's called U visa documentation, whereby a person who is undocumented but was the victim of a crime can obtain a visa within the United States by virtue of the fact that they were a victim of a crime. Now, that's where our victim advocates or our police agencies get involved. Someone will submit an application through the arresting police agency, usually through the detective at issue, or through the victim advocate for the district attorney's office. Now, if somebody applies for what is called a U visa, I, as the prosecutor, am obligated to turn that information over to the defense. One of the facets of criminal procedure and criminal law generally is I am not allowed as the prosecutor to keep secrets from the defense. So if there's something that I know about the case, I have to turn it over. That's part of my job. That means even things like somebody applying for a U visa. But those two protections, first, the bar on introducing evidence about somebody's legal status in a case, but also ensuring that somebody, if they are the victim of a crime and they apply for a U visa, they will not be deported. Those are the two central protections that we have for our undocumented population in California. So I hope that for our attendee, I hope that that at least helps or gives some sort of like initial guidance. Other great questions. Oh yeah, from Eve. And I'm sorry, I can't see your last name. I apologize. Can you give an example where a victim's legal status would be relevant for the defense to bring up? So I have seen it happen where a defense attorney, if a victim applies for a U visa, the defense attorney wants to say, well, you're actually only applying for, or you reported this crime knowing that if you reported this crime, you could apply for a U visa or you could apply for some sort of government protection so you wouldn't be deported. Now, if the defense wants to make that argument, we then have to have an evidentiary hearing. And part of that would be me going in front of the judge and presenting all the other evidence that I have. So, in the case of domestic violence, you can imagine somebody who has physical injuries on them, or somebody who was physically injured and you have a third party, maybe somebody who doesn't even know what was involved in this case, or like a ring camera video or something. I could bring in that evidence and sort of say, well, all right, Judge, I know the defense wants to say that this person being undocumented or their legal status in the United States, whatever it is, that that's relevant. But look, the video is, or the photographs are what they are. This person didn't make these things up in the grand hope of, maybe, just maybe I'll get a U visa out of this. That doesn't make sense. And so I've been successful in trying to think of a time where I wasn't. The last time was in 2011. In keeping that information out in front of a jury. The reality is that most judges can keep that information out so it doesn't come in. Because it's too prejudicial and it's confusing and it really distracts from the issues of, look, is there evidence of what the person did and what the actual crime was? The case is not about who the victim is or where they come from. So I'm going to move forward. I really appreciated that comment though, Eve. That was awesome. I want to move on to a question, and I'm so sorry to Geneva if I don't do service to your last name. I'm sorry, Zaire. If a victim is a person with intellectual or developmental disability, no conservatorship or guardianship, how can they follow along with the criminal justice process? Wow, that is an outstanding question. So, if someone has an intellectual disability, but they find themselves, and I guess it depends, because question one would be, are they a victim in the case or are they suspected of a crime and a defendant in a case? Because those are two different roles. So I guess maybe probably the best way would be to answer both questions. how can somebody follow along with the criminal justice process if they are, oh, sorry, your question called for if they were a victim. Um, if a victim is following along with the criminal justice process, it falls on the prosecutor and the victim advocate to explain things in a way that this person can understand them. What I'll say is, I've worked with victims of crime who were children. I've worked with victims of crime who were as young as 3 years old. Now, can that person understand everything about the process in which we're involved, or the nuances of a criminal case? Probably not. And if I tried to talk to them the way that I'm talking to the participants in this Zoom meeting, I don't think that would go very well. But I think that that's where it's incumbent upon a district attorney's office to probably assign a specific advocate who has training in dealing with people who have intellectual disabilities, and incumbent on a DA's office to ensure that you have people who are trained to serve communities where you have somebody who might have an intellectual disability. You're asking an amazing question, because it's an area where, no, we're not perfect at that. And I don't think that anybody could be perfect, but I think that it would be incumbent on the prosecutor to do their best. Now, some of those parts would be, or sorry, I think some of the most fundamental parts to ensure that a victim understands are, one, that they might be called upon to talk about what happened, ensuring that if they are called upon to talk about what happened, that the prosecutor and the defense attorney make sure that that happens in a setting that is not going to cause someone any emotional harm or any additional trauma. That is to say that the process of testifying, if needed, is not itself traumatic. And then I would say separately that they understand, more than anything, I think the most important thing would be the fact that we're here doesn't mean that they did anything wrong, depending upon the nature of the intellectual disability. Now, if you're dealing with a suspect, a lot of times that's when we're going to have a person who is in what's called 1368 status, meaning that the person is not competent to have the trial move forward, and criminal proceedings are suspended while the court figures out essentially what's going to happen with that person, whether that person will be gravely disabled and then will be either given some kind of a conservatorship. Those are the other sort of avenues that we have. All right, moving forward. From Sonetta Freeman, great question. All right, can a prosecutor speak on behalf of a defendant to ensure their punishment or treatment is handled in a certain way, say sent to a hospital instead of jail? Absolutely. So in terms of the overall way that cases are disposed of, the way that we have cases resolve. Now, at trial, you have a sentence that's ultimately decided by a judge. But earlier in the case, prosecutors and defense attorneys can try and agree upon what the ultimate outcome in the case should be, meaning what is the agreed upon sentence. And if a defense attorney or even the facts of the case present evidence to say, well, look, a person has serious mental health issues. This person clearly has mental health underlying causes that were essentially the catalyst for the crime. Prosecutors can agree to mental health treatment as a term of probation. Also, California law includes a provision for what is called mental health diversion, which is if somebody had a mental health condition that was the substantial cause of the criminal conduct, then the case can be what's called diverted, meaning criminal proceedings suspended. And that person is, instead of being convicted of a crime, that person is placed into a diversion program where they're given mental health terms instead. So prosecutors have a role in assuring that those programs are used in the correct way, but also being mindful of the fact that it's the prosecutor's job ultimately to do justice, to try and do the right thing, and not just to secure a conviction. So in trying to assure a result of, say, for example, mental health treatment instead of incarceration, that's going to depend upon the conduct in the case and a lot upon whether or not we have evidence of somebody who's a serial offender, somebody who has habitually repeated crimes of this same type in the past, or whether or not this appears to be something where, a good example is there's a certain category of crimes that present where somebody at a certain age when like schizophrenia starts to present itself. Kind of not to generalize, but that's something that prosecutors have to pay special attention to. So yes, you're exactly right. To Sonetta Freeman, that would be exactly the situation where a prosecutor would say, hey, let's stop for a second and think about what we can do instead of putting somebody into custody. All right. And so there was from another user, we also had the question, does each state have a different criminal process or system? Yes, absolutely. And where you're going to see variations on one, the process that goes into place before we actually get in front of a jury for a criminal trial. So I talked about the difference between a grand jury system on the one hand versus a preliminary hearing system on the other. California uses a preliminary hearing system because we have so many cases and such a large population. One of the things that I talked about was the idea that you don't need to bring a victim in to testify at a preliminary hearing. And that's because we have so much work going on in California. A lot of times in states that have grand jury systems, you actually have to bring in a victim of a crime to testify about what happened at that crime. California is a little bit different. There's also differences in terms of how conduct is treated. Some states treat the first DUI as an infraction or a traffic matter. Some states have different rules on domestic violence and specifically on the punishments that are in place for domestic violence. Now, the federal system has the same rules all across all 50 states. Each state has different rules for how, for example, either domestic violence or murder or gun crimes or even drugs are classified and handled and punished. So that's why sometimes you'll hear about sentences in other states for things like drug possession where you kind of go, I'm sorry, what? Like, what are you doing in Florida? Like, what are you doing in this other state where, somebody will be in custody for a certain period of time and you're going, man, California works really differently than that. That's because each state, that's a facet of each state sort of behaving differently in regard to their criminal laws. All right. And I'm not seeing any other questions right there. All right. And so I will open it up if there are any other questions right now.
Another question is coming in.
Oh, great. Not a problem. Cool video. All right. What the DA does. Thanks for dropping that into the chat. Appreciate it. Oh, and here's a question. Okay. Are there legal requirements for the DA when it comes to victims and informing them? Outstanding question. So this is what's called Marsy's Law. And Marsy's Law comes from a set of California constitutional rules that are put in place regarding Victims' Bill of Rights. So these are the rules for a prosecutor in terms of what obligations we have for informing the victim. The victim has the right to essentially know what is the outcome of the trial, to be informed of any disposition in the trial, and to speak to the court regarding their position on that matter. A victim also has the right to what is called restitution, meaning to be made whole. That includes being reimbursed for out-of-pocket expenses like any money that was lost, any monetary losses from the crime itself. So when it comes to a prosecutor's job, the prosecutor has the role of explaining to a victim, one, what stage of the case we're in right now, and also if there's going to be a disposition, the prosecutor has the job of explaining to the victim what the sentence is, what the offer is, and explaining that to the victim, ideally before the sentence is pronounced or any change of plea goes forward. Now I say ideally because sometimes it happens that if a victim may, after the crime has taken place, the victim may not want to be involved in the case. The victim may not want to return phone calls or may not want to answer the door if a prosecutor or a prosecutor's district attorney investigator like knocks on the door with a subpoena. That happens. And if that's the case, it can be difficult for a prosecutor to do what's called Marsy's Law compliance. When that happens, the prosecutor then has to put on the record, well, I contacted this victim on this day. I contacted this victim on another day, and I left the following messages. Now, it's not always possible for a DA to explain to a victim what the deal is going to be before it happens. And we can imagine that we couldn't just put the case on hold indefinitely because prosecutor's not able to get in touch with the victim. But the prosecutor does have to make reasonable efforts in that regard. So that's, I would say, when it comes to keeping the victims informed, the biggest way that we ensure compliance with Marsy's Law is through our victim advocates. Like that is, I will say in the time that I've been a prosecutor, which has been like really, so think like early 2010s to now, the big sea change that you've seen in the role of a prosecutor has been really the way that we now sort of handle more specifically violent crime, that really any drug crimes in the state of California, you're seeing those really sort of squeezed out and not being handled by the criminal process as much, with the exception of drug dealing. But it's also, I would say, the biggest thing is the robust role of a victim advocate within the DA's office. That has been the biggest change I've seen. Okay. And then I will open it. Again, if anybody has any other questions, I'm all ears.
There is one in the Q&A.
Oh, outstanding. Thank you.
Of course.
Wow. All right. Awesome question. Is there anything agencies, social workers, advocates can do to help that the DA sees? Meaning, and I'm going to assume that means I want to make sure that I understand this question. To help that the DA sees the case through. I mean, I'll ask for a little bit of clarification on that. Thank you. Oh, how can we help in these cases? Thank you. All right. So I always like to say when I'm working with victims and their families, I want more contact and not less. The thing that I want to know is that my victims are being treated well throughout the process, and that they are at least in communication, and that what's happening in the case is not a mystery to them. I guess I'll kind of back it up by saying, that I start from the fundamental place that victims didn't make the choice to be a victim. That's like the common ground, is that when I'm talking to somebody who's the victim of a crime, they didn't make the choice to talk to me. That's the reason why we're there. And so what gets really stressful for victims is that they're now in a position where there's now some system that they are involved in, that where they now are talking to me, they now have to talk to a lawyer, which nobody wants to do. And they're talking to me about a case that they had no choice in, like essentially whether or not they were a victim, and the fact that it moved forward. It really sort of happened. The underlying crime and the criminal process are not things that they would have ever have chosen. So when that gets so that is stressful enough by itself. What's more stressful and more scary is not knowing. So when I talk to advocates, when I talk to social workers, when I talk to anybody within an agency about what can you do to help, I want more contact with my victims and not less. Now that could be, and that depends, or it really doesn't matter depending upon how cooperative the victim is or not. Now, I've had victims who, outside of the courtroom, we've been, I mean, perfectly friendly. They know that I'm there to help. They know that I'm trying to essentially curtail something really violent that happened. But then they might take the stand and say, hey, you know what? They get up and they say, I don't remember, I don't remember, I don't remember. Uh, I can't judge that person for that. But if outside of the courtroom, we're able to hold a conversation, if I'm able to give them updates, if they're able to tell me how they're doing, that's what I need. The other thing that I always note is I want to know that a victim has people who they can talk to or go to when they are either not feeling safe or not feeling stable. I can handle a lot of things in the courtroom. What I can't handle is if the time between when a crime happens and when a case ultimately goes to trial, if in that time a victim is so stressed or so scared that they're destabilized and they do things like they have to self-medicate or they don't know how to deal with the stress and so they have like a panic attack, right? Those are the areas where I find that my cases are the most compromised, right? Because those are the things that I can't, um, those are the hardest things for me to help. So I find that ensuring that a victim has a safety plan, ensuring that a victim knows about a restraining order that was issued at the time of arraignment, ensuring that a victim has resources for counseling. These are all like the big picture, kind of big ticket items that we can do to help victims. And I hope that kind of answers it in as broad a way as I can. All right. From Marie Davalos, are culture, race, ethnicity, etc., considered when working with victims? Yeah, I'd say there's two different kinds of ways of looking at this, and there are two different ways to answer the question. On the one hand, when I handle a case, the thing that I'm not considering at all, and in fact, the thing that usually I don't really know much at all, unless of course somebody appears on body cam or I can like see a booking photo, is the race of an involved person. A lot of times, because of injuries, I may have information about the ethnicity of the background of somebody, but when it comes to the filing of charges, the job of a prosecutor is not to consider those things. The job of a prosecutor is to treat as best possible all people equally. Now, how can I be culturally sensitive? I will say that in California, there is a substantial portion of our population that speaks Spanish as their primary language. So I am an abysmal Spanish speaker. But when I meet victims, the first thing out of my mouth is, lo siento, hablando muy pésimo, perdóname. Because from there, I'm going to try and talk to them in Spanish. I'm going to do my absolute best, and I know that I'm going to fail. But the thing that I've found in life is if you show somebody that you're trying, that kind of goes about like 90% of the way. So when it comes to working with victims and their families, I'll talk with a victim advocate who's fluent in Spanish ahead of time about being sure that I can explain things in Spanish. That's pretty helpful. In terms of cultural sensitivity, it's very rare that we would take that into account in terms of how we assign staff or things like that. I don't think that in a modern DA's office, I don't know that that's appropriate. And I don't know that that's fair to victims of violence, that we would sort of slot in people who handle cases based upon either their color, their skin, or their ethnic background. But how do we do it? Mostly by making sure that we talk to people who have similar backgrounds. So that way, if there's issues of the cultural sensitivity the prosecutor needs to be hip to, that we try our best to honor those things. So that's maybe the best answer I can give you. But I mean, man, that's a training all in itself to Marie Davalos. And I love that question because honestly, I could spend another hour talking about it and I would love to. How do I see my work in relation to restorative justice? That's also a great question. One of the prosecutors who I used to work with and she is now at the California Department of Justice, was a woman by the name of Venus Johnson. And what she used to say was, look, our job is to essentially rehabilitate where possible and only punish if necessary. I think that's a really good lodestar principle to look at, meaning as a prosecutor, one has to understand that if, unless of course somebody is going to prison for the rest of their life, if a prosecutor imposes a term of incarceration, whether it's in county jail or state prison, that person will get out. So the question that prosecutors, and I think modern prosecutors, have to ask is, who are we releasing into the community again? And is that person prepared with better tools to make sure that this doesn't happen again in the future? Now, when we deal with lower level offenses, I think that through probation terms that include things like drug terms, somebody going to dealing with drug or alcohol issues, that stems a substantial amount of criminal behavior that you see at different sort of stages of life that people encounter. That's where you see the bulk of our cases sort of go away, where somebody has a case and then you sort of never see them again. That's the bulk of what happens in the criminal justice system, are cases that somebody, essentially you have a one-time interaction and then nothing forward. Where unfortunately a lot of my effort goes as a prosecutor is in the other like 1% of cases that come to the attention of police and investigators, which is people who are sort of repeat players, or someone who is on parole, or someone who has committed violent offenses in the past. Those are cases where the public safety concerns that are involved are such that I have to consider incarceration just as a matter of public safety. But again, that's an outstanding question, because I think that it comes back to that cornerstone function of rehabilitate and prevent this from happening in the future by giving somebody tools wherever possible, incarcerating only when necessary. I think that's the best answer I can give in that regard. And then I realize we are like super close on time.
We are doing great with time.
We are. I think we're like perfect. I realize we're like, it's to 11:30, I think, so we did it. But I do want to put it out there in case anybody has any other questions right now.
Yes, please ask your questions. And just a reminder that the PowerPoint presentation will be emailed later today or Monday, along with the
Yes.
survey. And we would greatly appreciate if everyone completed the survey.
Okay.
I
Thank you,
don't see.
Diane, and thank you, Renee. I really appreciated it. Thank you so much.
Yes, thank you for the comments.
Yeah, thanks.
Well, I think we could
All right, awesome.
wrap it up. Thank you, everyone, and thank you, Adam. Have a great day.
All right, you as well. Thank you so much.
Bye-bye.